Good evening to all the learners and academic counselors. Uh, Today onwards, we are going to have the new course MIR 23, that is the patent law. Miss Usha is going to take the sessions for this coming next 3 days, and after that for the project Mr. Prasad is going to take the sessions. So far, whatever the sessions we have conducted for the PG certificate program in patent practice, that already uploaded in our RC Visakhapatnam YouTube channel. If any student miss that, you can again watch that one. And also, even if you have the some doubts regarding the content, whatever the previous sessions, that also you can refer. And on behalf of the IGNOU Regional Center Visakhapatnam, I thank Mr. Prasad. In spite of his some health issue, he joined this session, and also arranging Miss Usha for taking the counseling sessions. I also thank Miss Usha for accepting our request and agreed to take the sessions. Both of you, we are thankful, and I request please go ahead with the sessions. Thank you.
Thank you. Usha will take it.
May you please on your mic, madam.
Good evening, everyone. My name is Usha Shah, and I'm from West Bengal. And I completed my BA LLB honors and also my master's on LLM, specialization in the area of IPR and cyber law. So today I'm going to take a lecture on the area of about the introduction portions about what is IPR and the rest of the procedural aspects as well. So I will start my lecture by providing this important areas, highlighting these areas. So if anyone having any doubt in the meantime, you can raise your hand or simply you can drop a message over there. I will answer all the queries, whatever we are receiving. Okay. So I'm going to start with the contention. So I feel there is hello, I'm audible.
Yes. Please go ahead, madam. You are audible very much.
Okay. So we would like to discuss first about the conception about what is IPR. So basically IPR is intellectual property rights we are talking about, right? So as we are why we needed this course or why this IPR is very much important, as if we started to saying that we encountered this IP like the IPR at every stages of our life today. For example, the design on the it's a very connected examples like that. If we are using a bed sheet, so there we are seeing there will be a lot of varieties of designs, and also the variants of patterns will be even there. So including the design on the bed sheet to the pillow covers, and also the other items which we are day-to-day life we are using, including like a water bottle, a cycle, a motorcycle, even though the kitchen itineraries and all, everything will be covered under the protection of the IPR. Okay. So not only that, even we can say that the other important things or tools we are being using for our academics perspective, or we can say for the business perspective, or the so many things will be there, including all the basic like electronic appliances which are being using in the kitchens also, that will also be covering under the IPS. For examples like the gas stove, the microwave, the refrigerator, the vehicle, the vending machine, even though apart from that, the book, film, and the music cassettes, tiles, paints, particularly everything we are using in the product, which of having the human ingenuity, which having a specific knowledge and skill. So along with that, the labor and the capital which are being invested for to creating a particular product, which normally falls under some kind of intellectual property, definitely. So the which had to be represented before the item could be lawfully manufactured, or it can be like after that it should be marketed. So in simple words, if we say that what is intellectual property, then we will briefly explain that in a simplific way. That intellectual property, it is an intangible creation of the human mind, which is usually expressed or translated into a tangible form that is assigned certain rights of property. Now, here we are talking about like for example, intellectual property include the author's copyright on a book or an article, or we can say a distinctive logo which design or representing a soft drink company and its products, or we can say that unique design which is elements for a website, or a patent, which maybe it could be the product patent, or maybe it could be the process patent which is need to be manufactured, like any culinary products, or any type of for example a chewing gum, basic chewing gum. If we seeing how it will be processed to become a not a candy, specific category of a candy and a different type of a candy, that is the chewing gum, how it will be processed based on the specific ways and procedure will be included to getting it a main whole product. So in patent world, it can be protected in both ways. Like for it can be protected as like a product patent, and also the process patent can also be protected. So now what is intellectual property rights we are saying? So like intellectual property rights, we can be defined that the rights which are given to the people over for a creation of their minds, like a new invention, new idea, new ideologies. Based on that, something can be produced, and that produced product need to have a commercial importance. Okay, so if any particular product having its feature to be marketable, or we can be sellable, or it can be purchased by somebody else, or mainly we can say that which is having a commercial value, then those things can only be get protected under the intellectual property rights. Now, if we simply say that any property can be protected for any individual's right, but here we are specifically focusing on the tangible products and intangible products, right? So tangible products are those things which can be touched, okay, and which you can see. So those are physical, though, like those things physically present, we can say. But on the other hand, like tangible example, if we say that, for example, like a land, a tree, a money, or anything it could be. So intangible in the sense of which cannot be touched, see, but it is existed, or that rights which are being needed, which having a biggest commercial value, and which is come from the human intellect. That is the intellectual property. Okay. Rather, it is having the basic difference from the physical property to intellectual property. Clear? So now if we say that how this property can be classified under the IPR as well, like one physical property is segregated separately, completely. Now we are having a different classifications of the intellectual properties as well. So in intellectual property, we need to be defined that the right given to the people which over the creation of human minds. So they usually give the creator an exclusive right over the use of only to his or her creation for a certain period of time. See, as we seeing all the legal rights we having, it is not absolute in nature, right? So simply once you get your some like property you will getting for a physical property, if you are getting, maybe that you will be hold the ownership will be for lifetime. But in case of intellectual property, it is not the same. So, in intellectual property, every type of IPR will be having its like limited period protection. So, as this refer like IP, which refers to some creative of the innovation or innovative minds, that will be intending or that will be including some kind of invention. It might be the noble idea, or not only that idea, but that idea need to be specified and codified, then it need to be produced and get licensed, then only that idea will be protected. Otherwise simply no idea cannot be protected in namesake of innovation or a conception of new idea. Okay, so the literary and artistic works also being get protected. For example, literary and artistic work we are talking about. Literary work means any kind literature related works. Like it could be a writing of a poem, story, then any kind of the other content. Now, though in a digital platform, we are having different type of publication of online contents as well. So this all are will be getting protected under the copyright. Okay. And after that, if we say that the symbols are also being get protected. So here the symbols means any kind of pattern, logos, colors, then commercialized what we can say that uh, clubbing up of different patterns in together and combination of different types of logos in it along with a specific shape. It might be an alphabetical order, it might be in only in a shape, it can be anything. So those things will be get protected under a trademark law. Okay. And including the protection of trademark as well, the symbols, name, images, designs, everything in will be in come together can be protected. So simply we can say that one particular IP need to be protected under the different branches of laws as well. So if we simplifying the whole content, and we can say that the categories of the intellectual property broadly classified into various forms but into two major categories. Firstly, the IPR that stimulate the inventive and creative activities, that is patent, utility models, industrial designs, copyright, plant breeders' rights, layout designs for integrated circuits, etc. And another part we can say that protected, that IPR that offers some information to the consumers. That is only the trademark and geographical indications. So, IPR in both categories seeks to address certain failures of private markets to provide for an efficient allocation of resources. But is IP is divided into these two category, which is first industrial property need to be covered under the specific the rights, the IPRs we are being stated, and also the specific copyrighted as well. So like specifically industrial rights of IP is called patent, trademark, industrial design, and geographical indication of sources. Now, the other part will be covering under the copyright or the subject matter of copyright are like which is including literary or artistic works such as novels, poems and plays, films, musical work, artistic works such as drawing, painting, photograph, sculpture, and any kind of architectural design for the buildings, etc. And these rights related to copyright, including those of performing artist. Like performing artist here in the sense is those who are performing to completion of a whole task. For example, in a film, to creating a film, there are different particular persons contribution of work will be involved. Okay, so in the legal point of view, they all the person who are putting their labor to completing the task of that particular film, they all will having a legal right on that particular task. Like particular full completion of task means we are here taking the example of a film. Okay, so here now the performances whichever the particular persons are being given over there, even though including the producer of the phonograms in their recording, the musical work, whatever has been happened to completion of the film or contributed to creating new music over there, who given the lyrics and also who composing the song. And after that, the completion of the whole music or the movie, where it will be broadcasted. So the broadcasters are also being get protected their rights under the copyright law, not patent, not trademark. Okay. Am I audible? Now we are discussing about the what are the specific codifications of laws we having which are being get protected under the Indian legal perspective or the Indian legal regime. We can say that in India we having total in 8 categories of the statutes which are covering the biggest dimensions of protections of different branches of IPRs. So the first content of the statutes we having, that is the Patent Act. So the Patent Act 1970 will be the law, the act will be covering all kind of patent act. Later on, the Copyright Act, all the copyrighted subjects matters and regarding rights will be protected under the copyright law. And the then the Copyright Act 1957 covering the Copyrights Act. Then all the trademark aspects will be covered under the Trademark Act 1999. Then Industrial Designs Act will be there, which is the Industrial Designs Act 2000 has came. That law will be covering all the subjective matter aspects of the different kind of designs, which is included to using for the protection of patent, trademark, or any other substituted rights or the laws will be provided over there. After that, the protection of the Integrated Circuit Layout Design Act also we have. So regarding to giving a protection for any integrated circuits or the integrated circuits layout design, which is being get protected under the Indian law under the protection of Semiconductor Integrated Circuit Layout Design Act 2000. And the another one another one IP will be which is you all are aware of it, I guess. So that is called simply GI. So GI stand for geographical indication. So geographical indication of any specific goods are being protected. So this all the regions of this GI goods will be protected under the specific statutes called Geographical Indication of Goods Registration and Protection Act 1999. After that, the other one, that Biological Diversity Act 2002. So here, the Biological Diversity Act is being created to giving a protection for all the types of the biological, like the diversity. We need to be protected, and including the microorganisms to all different kinds of the specific the elements what we available or we having in our nature. We are also being bound to protect that one to maintaining the sustainable environment. So after that, the another IP also IP Act we also having, that is called the Protection of Plant Varieties and Farmers' Rights Act. So protection of plant varieties and the Farmers' Rights Act 2001, which is dealing with to giving a specific protection for a particular specific type of varieties of new plants, and also based on that how those farmers have to be cultivated, and after that they are being producing and selling those foods. So for the specific rights are also being provided to them. So these IP is dealing with this particular branch. So if we summarize the whole classifications of this IP, we can see in India only, we having 8 major codified laws for protection of IPs. Though there are the different classifications of laws in India, like the whole world we have, but India is not yet accepting all those classifications. Rather, specific type of IPs of the other countries are being covered under our same act itself also. For example, being as a personality rights, we don't have any specific personality rights. Okay, but it is somehow indirectly being get protected, or impliedly it will be protected under the Copyright Act itself, which is called, or we can say the other one is character merchandising rights, neighboring rights. Those all are being get protected under the Copyright Act through the international conventions and the cooperation treaties, whatever for time to time has been happened. India is also signatory and also accepting all those rights. So now if we briefly say this different type of IP we having, they having a limited protections as well. Like as we stated, no rights are permanent in nature. So there should be some of the protection, specific nature of the protection of specific nature of IP will be specified through our statutes as well. So if we talked about that patent, so the patent Indian Patent Act only being provided for 20 years. Okay, and these 20 years will be counted since the date of the filing of the patent application, to irrespective of like whether it is filed with provincial or complete specification. Instead of that, the date of the patent is the date on which the application for patent is filed. Okay, so the patent will be only available for 20 years time span. So if the ending of the 20, before the 20 years last date of expiry, the patentee are bound to applying for the renewal application before the patent office, then only they will continue with their patent, whatever the new invention they have been having. Okay. Same in a similar way also, the trademark. The trademark is available for only for 10 years. Okay. So 10 years from the date of making of the application, which is deemed to be the date of registration. After that, the copyright. So here, the copyright is basically copyright is last for a period of 60 years in India. So these 60 years are also being divided into in such a way that we need to understood about it. The tenure of the 60 years will be calculated in such a way that this 60 year will be started counting after the date the day the copyright owner has died or passed away. Since that day to 60 years it will be get protected. So, and in cases of there will be a multiple authors in copyright, in such stages the 60 years will be started counting after the last author has died. Okay, so since that date to continuation of the whole year, it will be counted. And there are the different types of copyrights protection are segregated also. For example, for the broadcasting rights, it will be provided for only for 25 years, not 60 years. Okay. And okay, the another IP, if we say the registration of a geographical indication, the registration for the geographical indication, which is valid for same for 10 years only. After that, the duration of the registration of the semiconductor that is containing the chip layout design. Okay, so this layout is designed for a period available only for a period of 10 years, and which is counted from the date of filing an application for registration or from the date of first commercial exploitation. So anywhere in India or in any convention, convention, whatever for the time to time has been conducted, and the country which is specifically by the government of India or whichever is earlier, based on that the protection will be provided. But it is more or less it will be only provided for 10 years, that is specifically mentioned as our the semiconductor protected statute. Okay. After that, the duration of the protection of registered varieties like plant varieties and the farmers' rights, which is like registered varieties is different. So different, it is different type of crops. Okay. So namely, 18 years for the trees and vines. So 18 years will be provided for the trees and vines, and for the other crops, it will be provided for 15 years. Or any kind of other extended varieties will be available, that will be get protected for 15 years. Okay, but it is very much important, or it is extremely important to note that like once a patent has been published in anywhere or any country in the whole world, okay, it becomes a prior art, and consequently it is deemed to be in the public domain. So, in all other countries where the patent application was not filed or within the time stipulated, that is for the 12 months, which is specified as per the Paris Convention. Okay, and from the date of the filing of the patent application in any country for convention application or the pet application is will be filed. So again, within that same stipulated time, so it may be like 30 to 31 months from the date of the earliest period. Thus, any person residing in the countries where the patent has not yet been filed or can exploit the patent for commercial benefit in that country without any restriction whatsoever and without any obligation to the patent holder is required. So, the whole contrary of this classification and the conception of what is IPR will be concluded in a simplific way that whatever the IP specifically we having, we somehow need to be giving the protection for a specific in purposes for a specific period of times only. So now let's briefly explain about the what is the history of these IPR rights, or we can say that how these IPR rights will having its evolution since the earlier period to presently, and specifically this historical perspective will be given to the overview about in basically based on India only. Okay. So George Alfred Depending is supposed to be have made the first application for a patent in India. So and this application has been filed in the year of 1856. So that era it was the first time in the whole history the patent application has been filed. So on February 28 to 1856, the government of India promulgated legislation to grant what was the term as a exclusive privileges, like exclusive privileges for the encouragement of innovation of new manufacturer. Okay, so this is specifically first time has been protected under the British law that period point of time in 1856, that is that Patent Act of 1856 that time prevailed. So a civil engineer, George Alfred Depending, first get a grant of license of a patent. So these patent they are being getting from the grants of Lane, that is a Calcutta petition of the government of India for granting those this kind of exclusive privileges for their innovations, or like specifically his innovation, like the particularly. So they are being focusing on a particular task for to getting its patented, an efficient punk okay, an efficient punk pulling machine. It is an the patent is basically on the protected, and specifically we can see the tenure that time that on September 2nd, Depending submitted the specifications for his innovation. That is innovation for that particular punk pulling machine. Okay. And this invention along with drawing to illustrate its work. That particular application is being clearly specified about how this machine will be functioning, not only to the documentation part, rather it will be in in such a smallest define like smallest illustrative way. They are being explaining the whole process of how this machine will be working and how it will be get protected. Okay, so that's why the drawing of that particular machines of working task to task and which is illustrated at how it is being working has also been mandatory to writing down to that patent application. So after that, these were accepted. This particular patent has been accepted, and the innovations was granted the first ever intellectual property protection in India. So, if we trace down the history of the major IPRs, like for example, if we say the major broadhead of IPRs they having, the copyright law, patent law, and trademark law. So, we see that the first time in India, the Copyright Act has been get protected. So this more like the modern copyright law, which is developed in India gradually in like almost more a span of like timing of 150 years. So copyright law entered in India during the time of 1847, and through it is entered through an enactment during the East India Company's regime. So according to this enactment, the term of copyright was for the lifetime of the author plus 7 years post-mortem. So, but in no cases could be total term of the copyright exceed a period of 42 years. Initially, it will be provided in such a way. Later on, the government could grant a compulsory license to publish a book, like compulsory licensing for to publish a first book, which is like that any if the owner of the copyright upon the like of upon the death of the particular author refuse to allow its publication, like if the particular person is alive, then only it will be published. So later on, the act of the infringement comprises in a person's unauthorized painting of a copyright work, like or what we can say as a part of the attempt of sale, hire, or exploration for purposes, or we can say the purposes for the selling, publishing, exposing of sell to hire in such terms. So suits or action for the infringement was to be the instituted in the highest local court exercising the original civil jurisdiction. The act provided specifically what under a contract of service, that is the copyright in any encyclopedia, review, magazine, then periodical work or work published in a series of book or parts, which shall vest in the proprietor, projector, or the publisher or conductors. So infringing copies were deemed to be copies of the proprietor of copyrighted work. But it is here importantly noted out that, unlike today, the copyright in a work was not automatic. Okay. So the registration of the copyright with a home office was mandatory for any one of the particular person who wants to get protected under the copyright or the copyright protection for their ideas or the work. Uh, like uh, however, the act also specifically reserve the subsistences of the copyright in the author and his right to sue for its infringement to the extent available in the law other than in 1847's act also. So the at the time of its introduction in India, the copyright law had already been under development in the period of British period. The Britain already been drafted a basic format of this copyright law, and over the time, the provisions of the 1847 enactment, which is reflects the learning from the deliberations during this period. So the another phase, if we say that in 1914, the Indian legislature enacted a Copyright Act, which merely extended most proportions of the United Kingdom's Copyright Act 1911 to India's draft. It had, however, make a few minor modifications will be there. So, firstly, if we say that it introduces only the criminal sections for the copyright infringement, which is containing section 7 to 12 of the Copyright Act that time. And secondly, we can say that it modified the scope of the term of the copyright. After that, under the section 4 of the sole right of the author to produce, reproduce, then perform or publish a translation of the work, which shall subsist only for a period of 10 years from the date of the first publication of the work. Later on, the author, however, retain her sole rights like if within the period of 10 years she published or authorized the publication of her work, then a translation in any languages in respect to that language will be acceptable. Then in the era of 1914, the 1914 Copyright Act was continued with minor adaptation and modification till the year of 1957 Act, which was brought into force on 24th of January 1958. So this is how our Copyright Act 1957 got get evolution from its specific time to time and get protected with the various rights. One more point we like to include here, that as per the international perspective, if we say over there that different time in the different timing, the various different conventions, international conventions, covenants, those all are being become the important part to getting protection, giving a more protection of the copyright in the worldwide perspective, or the jurisdiction is also will be provided. So if we say that the international legal regime relating to the IPR based on the copyright or any kind of IPR protection, there will be the major international conventions. We like to highlight it over there. First will be the Paris Convention, and after that we can say that the Bonn Convention, Rome Convention, WIPO Copyright Treaty, then WIPO Performance and Phonogram Treaty, then TRIPS Agreement. There's so many the other international instruments are very much crucial to getting the shape of the current Indian IPR laws, because India is time to time become the signatory of those convention, and which is specific convention related to specific protection of IPR is also being introducing in our presented IP Acts itself through a form of a modification or addition to that particular our copyrighted act. Okay. Now we are going to discuss about a Okay. Now we are going to discuss about a brief history about the patent law in India. So, if we say the first legislation in India relating to patent was the the Protected Act under the Indian Patent Act 1856 during the British period. So the objective of this legislation was to encourage inventions of a new and useful manufacturer, like the useful manufacturers, and to introduced a new inventor. Okay, that inventor need to be disclosed a secret of their invention. So the act was subsequently repealed. The particularly this 1856 Act was repealed by 1857 Act, since it had been enacted without the approval of the sovereign. So after all, this phase is over. Then a fresh codified legislation for granting us exclusive privileges was introduced in 1859 era through the act of the Patent Act 1859. So Same in that colonial period itself, this legislation contains certain modification of the earlier legislation only and named and granted of exclusive privileges to useful innovations only, and also included the extension of priority period from 6 to 12 months. So these priority period which is being provided, the 6 to 12 months granted from the Paris Convention. Okay, and the after all, this particular act also excludes some importers from the definition of the inventors. And later on, the 1856 Act was based on the United Kingdom's Act 1852, with certain departures, including allowing the assignees to make application in India and also taking prior public use or publication in India or United Kingdom for a purpose of ascertaining novelty. Later on, the another phase, if we can see, seeing the period from 1859, which specifically provides the protection for the invention only, and not for the designs of wherever the United Kingdom had been protecting various designs from 1842 onwards. So, to removing this lacuna, the Patent and the Design Protection Act was passed in the year of 1872. So, this act was amended, the 1859 Act, to include any new and original pattern or design or the application of such pattern to any substances or articles of manufacture within the meaning of a new manufacturer. But later on, that was like this 1859 Act was again amended in 1883, and which is introduces provisions to protect novelty of the invention. So, which prior to making application for their protection were disclosed in the exhibitions of India. So, a grace period of 6 months was provided for filing such application after the date of the opening of such exhibition. So, here this exhibition is only being called for that point of time, that era, that calling to the all the world, that all the inventors are welcome to participate in that invention, exhibition, and they will produce their innovation, how it will be useful, and what will be their the utility, what is having the utility to get it commercialized, and that's why they need to be get protected. But somehow it is not being that much revealed in a specific protection, so that's why that steps is not will be acceptable to the whole world. So later on, again in 1888, the new legislation was introduced to consolidate and amended the law relating to the invention and designs in conformity with the amendments made by the UK law. Later on, in 1911, the Indian Patent and Design Act 1911 was brought in replacing all the previous legislation on patent and designs. So this act brought patent administration under the management of control of the patents for the first time. So this act was amended in 1920, which provides for the entering into reciprocal agreements with UK and the other countries for securing priority. So, another phase was in during the time of 1930. Again, the amendment were made to incorporate the inter alia provisions relating to grant of secret of patent. That is also currently known as the trade secrets. Then, patent of addition use of the invention by the government. Another one will be the power of the controller to rectifying or registering of the patent, and increasing of the term of the patent from 14 years to 16 years. So this will be the changes, and the main major highlighted amendments has been added during the time of 1930. But later on, in 1945, another amendment was made to provide for filing of provisional specification and submission of complete specification within 9 months. So it is being bound by all the applicants that they need to be completed their whole process within that specific period of time itself. So now we can say about the post-independence era, which is we can highlight it that the major areas was it was felt that the Indian Patent and Design Act was not fulfilling its objective. So it was found like desirable to enact a comprehensive patent law, which owing to substantial changes in political and economical conditions in every country. So, according to that particular objective only, the government of India constituted a committee under a chairmanship of Justice Dr. Bakshit Tekchand, a retired judge of Lahore High Court in 1949, to review the patent law in India in order to ensure that the patent system is conducive to the national interest only. So the committee submitted its interim report on 4th of August 1949 with recommendations for prevention of misuse or abuse of the patent rights in India and for amendments to section 23, 24 and 23 capital A of the Patent and Design Act 1911 on the line of the United Kingdom's Act of 1919 and 1949 only. Okay, so based on these recommendations of the committee in the year of 1911, the act was amended in 1950. Okay, the Patent Act in relation to work of the invention, in relation to work of the invention and compulsory license for the it could be the compulsory licensing or for the revocation for the license, that purposes. So later on the phase we can see that in the era of 1952 the amendment was made to provide compulsory license in relation to relation to patents in respect of food and medicines. So insecticides, then fungicides, and for the process for produce the substances or any invention relating to the surgical or curative devices or through this particular act of 1952 only get protected. So afterwards, the concept of the or on notification by the central government only. So the like which is based on the recommendation of this same, the committee has been comprises by the chairmanship of Bakshi Chance. So they are produces a bill like after this recommendation, based on this recommendation of this committee only, a bill was drafted and introduced to the parliament in the year of 1953. And however, the bill lapsed on the dissolution of the Lok Sabha. So, in the government of India appointed again Justice N. Rajagopal, N. Rajagopala for to monitor one more committee for to examining the questions of the relevance of the patent law and advise the government accordingly. So the report of the committee, which comprised of two parts, was submitted on September 1959. Okay, so this report, the first in hand of the part of this report, deals with the general aspects of the patent law, and the second part and the what so the first part dealt with the The first part dealt with the general aspect of the patent law, and the second part gave detailed note about the several clauses of the Lapse Bill of 1953. The first part also dealt with the evils part of the system and the solution. Solution about the what are the recommendations in regard to the law, and the committee recommended retention of the patent system. So, despite its shortcomings, this report recommended major changes in the law, which formed the basis of the introduction of the patent bills. That the patent bill again was drafted in the year of 1965. This bill was introduced to the Lok Sabha on 21st of September 1965, which again lapsed. But the next era in the 1967, an amendment bill was introduced and referred to the Joint Parliamentary Committee. On the final recommendation of this committee, the Patent Act 1970 was passed. So this act replaced and repealed the old Act of 1911. And however, 1911 Act continued to be applicable to only to design. So most of the provisions of 1970s Act was brought into force in 20th of April 1972 with the publication of the Patent Rules 1972. So this act remained in force about 24 years till December 1994 without any change. Like an ordinary effective certain changes in the act was issued at 1994 only. So which ceased to operate after 6 months. So subsequently, the another ordinance was issued in 1999. So this ordinance was later replaced by 1999 Patent Act, and that was brought into force respectively from 1st of January 1995. And the amended provision was provided for filing for application for product patent in the areas of drug, pharmaceuticals, and the agrochemicals. Through such patents were not allowed. So, however, such applications were to be examined only after 31st of December 2004. So, meanwhile, the applicants could be allowed it exclusive marketing or to selling or distributing these products in India. So, subject to fulfillment, obviously, about their made with certain conditions, obviously. So the third amendment of this patent was introduced through a patent ordinance in 2004 with effective on from 2005. This ordinance was later replaced by the Patent Act 2005. Until now, this Patent Act 2005 is brought in force. So now let's briefly explaining about a little bit about the history of our trademark in India we have. So the like while some from the proprietary protection from the marks in India dates back several like millennia, or the India statutory trademark law. It's dates back from its origin from till the year of like since the year of 1860. So prior to 1940, there was no official trademark law in India. Numerous problems arises on infringement law or passing off, etc. And these were solved um, by application of Section 54 of the Specific Relief Act 1877 in India. And the registration was obviously adjudicated by obtaining and declaration of the ownership of a trademark under the Indian Registration Act 1890. To overcome these aforesaid difficulties, the Indian Trademark Act was passed in 1940. This correspondent with the English Trademark Law. So the repeal of the government Trademark Merchandising Act gave a raise to the Trademark Act of 1999. This was done by the Government of India so that the Indian trademark law, in compliance with the TRIPS obligation on the recommendations of the World Trade Organization. The objective of 1999, the Act is to confer the protection to the user of this particular the specific trademark on these goods, or prescribe certain conditions on acquisition, legal remedies for enforcement of the trademark rights. Okay. So we would like to discuss about the areas of specific some specific terms which we need to understood under the Patent Act. Okay. So firstly, if it all like we are talking about the Patent Act. The whole conversation right now today we are covering about the all the patent laws, the specific definition words included over there, important key terminologies, and also the procedure for patent registration of India. How or like what will be the process we are following? How we need to be get protected? What are the mechanisms or the things we need to be followed? These are going to be we are going to be discussed over out here. So firstly, if we say that the term we need to understood first about it is called that invention. Now as we are talking about patent, right? So, in patent only being provided to a specific invention only. So, before getting to get protection, we need to first understood the term of invention first. So, what is invention, or what means invention is? So, if we see our Patent Act itself, it is defining the major term. The patent invention means a new product. It could be a new product or the a particular process to making of that product. So both the product patent and the process patent, both. Okay. So invention means a new product or process involving a inventive steps and capable of industrial application which have. Then only it will be called an innovation. So, inventive steps here we need to focus on about how these new innovation will be completely different from the already existed any patentable product. Okay. So, and the inventive states basically, in simplifying, we can explain that a feature of an invention that involves technical advance as compared to the existing knowledge or having economic significance or both, and that make the invention not obvious to a person like skilled in that particular art, then it will be called as a inventive state. Okay. now a patent means a patent for any invention or granted under this particular patent act only. Okay. After that, we are like to discuss about one more term you need to understood about that, assignee here. So what does it mean of assignee here? Assignee means like including a assignee of a assignee and the legal representative of a deceased, or we can say refer to an assignee of a person including references to the assignee of a legal representative. Basically, assignee means the particular patent owner, whenever they are for a specific period of time transferring their patented rights or the patented invention to somebody else for to using it as a commercial purposes, that the person who is obtaining the patent license of assignee, that particular person is called the like you having the right to utilizing the patent for the commercial purpose on behalf of the original patent owners consent only. If they are not obtaining the patent without the consent of the real owner, then obviously it is a amount of infringement. So when it will be applicable, this scenario has been came when like not only in patent, rather in any IP, whatever is being giving the protection by the government. Okay. So in that, all the IPs is provided for a specific period of time. So within this specific period of time, all the IP owner need to be utilizing all this IP for a particular commercial purposes. Because of that, they are getting this protection. So if we talked about patent, so let's take an example. If Mr. X was getting a patent on a particular drug or medicine, which is a vaccine of COVID, okay, now they know the procedure of how it will be produced, or it will be that product will be made and everything. So they got the patented license on it. But after getting the license, Mr. X is not utilizing this patent. Uh, Patent in the sense of they are not making the drugs, and they are not selling those drugs also. So after getting the license, it will be the idea that innovation will be kept in like it is not being revealed to the common people, or it is not even using for the commercial purposes. So it is not allowed it as per our Indian laws. The inventor must be using their patented invention for the commercial purposes. If they are not using, then it will be there will be two conditions. Either the particular person can be surrender their rights to somebody else, or assign these patented rights to somebody else for a certain period of time to making it to published, or either the government they surrender it to the government itself, that government can take it and produce the medicines and provide it to the common people, or maybe will be commercialized. It will be using as per the requirement of the situation or the product whatever is being processed. So uh, now here one more term you need to understood here, that is the controller. So the controller here means the controller or the general of patent, design and the trademark office. And the different convention we having that need to be complied with this patent act as well. So convention country means the country or a country which is member of a group of countries. So basically, if a two, like for example, if we don't having a specific laws regarding for a protection, so and a new innovation has been originated in USA, and which is not yet registered in India. But that is the first innovation has been already registered in USA. So it doesn't mean that any Indian person can taking that idea, and just because it is not protected in India, they are first comer to filing the application and they can be get protected. It cannot be acceptable as per the international legal norms and protection. So here will be the conventional rights will be came to play over there. So the US person will getting the conventional rights protection over there. Now, the term is exclusive license. So the term exclusive license means a license from a patentee which conferred the license or the license of a person authorized by him, or to exclusion of all other forms including the patentee and any other rights or respect to patented invention. An exclusive license shall be constructed accordingly. Another more term is government undertaking. Now, government undertaking means any industrial undertaking carried on by a department of the government or a corporation established by a central, provisional, or a state act which is owned or controlled by the government, or by a government of a company as defined by the Patent Act itself, or by an institution wholly or substantially financed by the government. Those all are formed a part of the government taking. So those industry undertaking also can be performing or to getting the practice of such patent. Like if any patent will be granted in the name of the government, then these are the undertaking bodies can be performing or utilizing this patent for the commercial purposes as well. So now we are being going to discuss about inventions. Now, what are the category of inventions? Like you are already aware of it, I guess so, that what can be patented, right? That any invention which is having its unique features, that means if they met with the principle of novelty, means if they accepting the new idea, new inventive steps, it will be present in that idea and which is not get protected earlier, then only such innovations will be get protected. Now, what cannot be protected under the Patent Act? That is specifically mentioned under the Indian Patent Act 1970, Section 3 and Section 4, containing the specific grounds for the non-patentable items will be listed out there. So, if we briefly explaining about what inventions are not patentable, then firstly we can take like an invention which is in frivolous or which is claims anything which is obviously contrary to well-established the natural law. So that invention definitely cannot be protected, firstly. And secondly, an invention, the primary or intended use to commercial exploitation of which could be contrary to the any public order or morality, or which causes any serious prejudice of a human, animal or plant life or health or to any environment, then definitely such invention could not be get protected. Thirdly, if we say the the mere discovery of a scientific principle which is already being invented and or formulated for any only just the abstract of that particular invented theory, or discovery of any living thing or non-living substances occurring in the nature. So these kind of inventions are not going to be get protected. So fourthly, the already known substance which does not result in the the enhancement of the known efficiency of that substance, or mere discovery of any new property or new use for known substances, or the mere use of known processes, machines, or unless known the process result in a new product or employ the last one new reactant. So that could not be definitely get protected. Fifthly, we can say that a substance obtained by a mere admixture of resulting only in the aggregation of the properties of the components, therefore, or a process for producing such substances, that also could not be protected. Sixthly, we can say that the merely arrangement or rearrangement of duplication of known devices is functioning independently of one and another is known way, those also cannot be protected. Another a method of horticulture and agriculture, that method cannot be protected or patentable. Later on, eighthly, we can say any process for the medicinal, surgical, curative, prophylactic, or other treatment of human being, or any processes for a similar treatment of animal, or render them free of the disease, or to increase their economic value or that of their products, will also not be protected. Ninthly, plant and animals in whole or any part thereof other than the microorganism, but included the seeds, varieties, specific and essentially biological processes for production of propagation of plants and animals are also not be get protected. A mathematical or a business method or a computer program per se of the algorithms, these are also cannot be protected. So, a literary, dramatic, musical, artistic work, or any other aesthetic creation whatsoever, including the cinematographic work or television production, that also could not be patentable. Next, a mere scheme of rules or methods of performing mental act or method of playing a game, that can also not be get patented. A presentation of information is can also not be get patented. Then topography of integrated circuits are also not get protected under as a patent. An invention which in lastly we can say that an invention which in effect a traditional knowledge or which is an aggregation or duplication of known properties of traditionally known components or components which is already being existed, so in the nature itself or through our traditional knowledges and all, so those things can also not be patentable as a invention. So these are the basic 15 items or the grounds are being specifically specified about in such terms they will be definitely not get protected under the innovation or which could not be protected as a patentable substance. Okay. So the another last and most important, the other section has been covering up that any invention relating to atomic energy which shall not which is which shall not be get protected or protected under the patent law. So atomic energies are also not patentable items. So these are the basic the forms the grounds where the patent cannot be provided or available. Okay. Now the specific question has been came in our mind that in India who are the eligible person can file a patent application, right? So in India anybody can file an patent application. To filing a patent under the Indian patent law, it is not necessary that the person has to be a citizen of India. It can be a foreign national, it can be an Indian national, anybody, everybody is allowed to filing a patent application and get protection under the protected their innovation under the Indian patent law. Okay. So, so for to getting a patent applicant can by himself is also file a patent application before the registered office or on behalf of the applicant, any assignee or the legal representative on behalf of the inventor can also be file an application. One thing we need to note it out here that if the assignee filed the proof of the assignment has to be submitted along with the application, then the application can be national of any country. Okay, so any person could be eligible to filing the patent. So basically any applicant can file a patent application before, like India we having in four region we having four offices where it will be protected the entire jurisdiction of India itself. So if we say that the eastern portion, the under the eastern portion, the major patent offices in India are four. First is Kolkata, second is New Delhi, third is in Chennai, and fourth is in Mumbai. So all the eastern zone or the eastern part places will having the jurisdiction under the Kolkata's office. Okay, and the all the northern parts of India having the jurisdiction under the New Delhi Patents Office, and the all the southern areas of the India having the jurisdiction under the Chennai's office, and the all the western area western parts of Indian states and the places are covered under the uh, Mumbai region or the Mumbai's office, which is the Center for the General Patent Design and Trademarks Office. Wherever there one registrar will be sitting over there, and simply they need to be draft the application and they need to submit over there. So this is the major fourth areas of the region will have. So, during the time of filing the application, the documents we need to be submitted while applying for the patent application is there will be form number 1, form number 2, form number 3, form number 5, and form number 26. Okay, these are compulsory. To filing form number 1, the form number 1 is applicable for uh, application for the grant of patent. Form number 2 will be provisional for completing the specific category of the patent, for which type of patent they are being taking, or the details about it will be there. Form number 3 containing the statement and undertaking by the applicant, like whatever the invention or the idea they are sharing, that is in original in nature, like of that, all the areas will be explained. Now, form number 5 need to be used for the giving the declaration as to the inventorship, that how this invention become the new one. Okay. Then form number 26 is also need to be used. That form number 26 authorizes, like it will be giving the authorization of the patent agent or any other person on behalf of the patentee if they are going to submit the application on behalf of the inventor. Okay, so priority documents details have to be filled for a conventional application purposes. Okay, if it is having any conventional, like any other country, foreign country, if it wants to get registered in India or registered as a patent protection in India, then they need to be giving the priority documents as well, that the conventional documents and other the documentation whatever they have it need to be produced before the office. So let's briefly explain about the procedure of filing the patent in India. So, the procedure for filing for patent registration in India, we are going to classify these things into 7 major stages. Okay. So, every stage is very much crucial and important to understood in detail, because if you are not being able to comply with one particular step, then one application of the patent will directly got rejected and the second chance will be provided. So firstly, if any particular person wants to get protected under any protected under the Indian Patent Act, being as an inventor, so they need to be first they first need to be find out the need to be find out about the patentability of the work whatever they are been working. So the first stage, the first step they need to be take, that is the patent searches. So in the beginning phase, there is The patent searches which is being provided important stage because it will giving the clarity to the patent application, like the patentee about how their work is become important, or whether the idea or the content, whatever they are trying to get the protected, such innovation is whether it will be already got registered to any other country or not, to need to check on that. So prior art is important to classify or to identify that whether that invention is already being registered the worldwide or not. If it is not, then the inventor is eligible to file the application to be get protected. So the application in the first beginning stage need to prove or to need to check the novelty of that of such innovation. Okay. So novelty, the term novelty, how we need to understood that it will be it having the novelty or not. So our Supreme Court of India, our Supreme Court of India in 2013, through a landmark judgment, it is been defining properly about that what is novelty and when an innovation can be covered as a unique or met with the new feature or the inventive steps, right? So you can refer the case laws that Novartis versus Union of India 2013's landmark judgment, which is defining the definition properly the novelty. That means it should be a new idea and it need to be it has to be a inventive steps and which cannot be against any kind of like public order, morality, or anything. It cannot be violating on any norms or something, or which also definitely not any like the all the grounds 15 grounds are mentioned. No, when the patent cannot be protected, it should not be made with this criteria. If it is excluding of all of this, then it will be called as a novel or unique idea. Okay, or the unique invention. So the first stage, we need to do the patent searches. That is the most important task we need to do. Okay. The second stage. Now, the second stage is very much important because here we need to draft the patent. So the applicant of who is filing the patent application, they are they are drafting the patent application for filing before the register of the office. So these drafting including all the specific information about the patentee, okay, that patentee, the applicant, and including all the forms the prescribed earlier, including they need to be mentioned the innovation in writing in a particular techno-legal language, which is known as the specification about the innovation. Okay. So after completion of this drafting, the applicant is ready to go for the third stage. Okay. Now in third stage, the patent applicant need to be file the patent application. So now the applicant need to identify what classification of patent that inventor wants to get protected. Clear? So in India, we having in total 6 different type of applications of patent filing are basically happen. Okay. So the firstly, the ordinary patent application for an ordinary task, or if it is a new in India itself, so simply it's a classification is first is ordinary application. Another second one is the PCT application, that is Patent Cooperation Treaty. If any patent is already being protected in any foreign nation, okay, and that similar patent wants to be get protected under Indian region as well. For example, for any particular goods or brand, something need to be produced, how produced to that particular thing, it's already been protected to any other country. So the same things are needed to in India, which is needs also being get protected. So the same country can file an PCT application before in India to get the same protection as the inventor is getting their like region country. The third application will be the national phase application, and fourth application is the PCT international application, and the fifth one is conventional application, and sixth one is divisional application and additional applications. So these are the 6 different kinds of patent applications are being available for filing. So based on the inventor, uh, specifically whatever the region of the nature of the invention will be there, based on that the applicant will be filing the application. Okay. Now the fourth major stage is, in this fourth stage, the application. After filing this application will be published of the like in the fourth stage. Basically, publication of this patent application is being happen. So whatever the inventor is submitting the application before the registrar of the patent office, the registrar is accepting the application, and later on immediately the day of the application, their application is need to be in public domain. Okay, so after filing the form from like the day of the application till 18 months, next 18 months, it is published on the official journal of the patent office for its like it is open to all the public. That it is opening for the public because public domain, because if somebody like maybe in India or outside of the country also, if anyone having any kind of objection regarding that, then they can raise and they can preview about it. So they can raise an objection before the registered office within this specific period of time. So after completion of this 18 months, the day of the application of the inventor file, the fifth stage, in the fifth stage, the applicant can request the examination of the patent application before the registrar of the patent for the patent prosecution. Okay, so in this So in this phase, they are being allowed like the if within this specific 18 months, uh, since they are filing the patent, that 18 months will be the application was in public domain. If no doubts is being arised or no complaint has been received before the registrar of the patent, then the inventor can request the registrar to examination of the patent application for the patent prosecution. Okay, but in case if there is an objection, then it will be next eight. It will be then again within the 48 months. The anybody, if they are requesting to the authority, then they will be sending the summon to that particular person, that the who is raising the objection. They need to be present before the registered office, and also the applicant will also be present before the office. Then the hearing will be conducted, and if the patent officer is being satisfied that the inventor is the whatever the subject matter has been produced, the inventor is not infringing somebody's already patented rights, then only the grant of patent will be, or the grant of order of patent license will be ordered. Otherwise, if it is seen that the applicant is filing an invention application which is already being granting the license to somebody else, then the patent application initially will be rejected. Okay. So this is the basic procedure or the steps for filing an application. So the last stage, the seventh stage, we are saying that this stage is important for that renewal period. So once a applicant got their patent license, the day they are filing the application to continuation in next 20 years, they will be enjoy the rights of the exclusive right on their patent. So before expiry of the last date of this 20 years completion, they need to be file a renewal application before the registrar. Then only they can continue with their exclusive right. Otherwise, it will be surrendered to the registrar, and the registrar can be used, or that right can be transferred to the government of India. So this will be the basic procedure of the right. And after completion or getting the registered, after getting the grant of order of patent license, after that the applicant will be initiated or instructed to pay certain amount of the application fees about the categories of the different categories of the patent application, howsoever they are filed. They need to be the prescribed fees. Based on that, their license will be provided. The same thing also will be applicable when it will be for the patent renewal as well. Patent renewal also, they need to be paid a certain amount of fees. So here we are already completed the content of the idea of about the covering the topics we having to discuss today. So is there anyone having any doubts till now or having any query?
Madam, one query.
Yes.
I had heard about, I have not gone through that much about the literature. So, seeking clarification that there is a uh, final specification and preliminary specification, something at the stage of filing of the patents.
Yes.
Yeah. So, what exactly are they like?
So the preliminary stage is like that. We need to be focused on majorly the prior art searching. So prior art searching here is the preliminary stage. We need to first, it will be checked by the registered office that whether the similar type of any invention will be got registered earlier or not. Or if it is already registered, but some modification is being kept. But now that modification also having its different features. If it is having a different features, or it might be using for a different kind of treatment or giving a different commercial aspects of protection. So whether it is there or not, that will be the preliminary stages. It will be identified first. And in the preliminary stage itself, it will be provided, like it is in public domain, it will be available for the all the common public, that anybody which having its, whether it being violating any rights of already registered any inventor or not, that will be given, and like that will be basically prioritized first, that nobody's rights already who are getting the patent protected, their rights should not be get violated. And also the application including all the proper documentations and the process for the techno-legal languages for that basic innovation has been done, whether it will be clearly, specifically, step to step mentioned or not. So this prior search and this preliminary stage is very much crucial and important part of to filing this any innovation under the to get a patent protection first. Any other queries, sir?
Thank you, ma'am.
Is there any other query? Is there having any doubts or any query? You can drop the message in the chat box or keep a note on those doubts. We can discuss in the next class also. So thank you for all of you. We here to ending the session. Thank you for joining. So here we are winding up today. We will meet you tomorrow.
Thank you so much, ma'am.